Subscribe the channel for latest updates. Press the bell icon. Get ready for the dictation at the count of 3, 2, 1, start. The petitioner was a company owning textile undertaking which was subsequently nationalized and taken over by the central government under the Sikh Textile Undertakings Nationalization Act 1974. The petitioners contended that Section 4 and 55 of 42 Amendment Act 1976 to the Constitution of India were constitutionally invalid. Section 4 substituted the words in Article 31C as all or any of the principles laid down in Part 4, which earlier was restricted to only Article 39, which thereby took away judicial review of any law on any alleged violation of fundamental rights guaranteed by Article 14 and 19 if it supposedly seems to further the principles of the directive principles of state policy. Section 55 inserted clause 4 and 5 in Article 368, which swept away judicial review from any amendment made to the Constitution by legislature, including Part 3 Fundamental Rights of the Constitution. Relying on the decision in Keshavanand Bharati versus State of Kerala AIR 1973 SC 1461 that Constitution is heritage, hence do not destroy its identity, it was contended by the petitioners that since Constitution itself provided limited powers of amendment, Parliament could not, under the exercise of that limited power, enlarge that limited power to absolute power, and hence Section 55 was unconstitutional. Also, regarding Section 4, it was argued that though directive principles were mandatory as the ends of government, they could be achieved only by permissible means, that is, by reading them in harmony to fundamental rights. But Section 4, which made the fundamental rights subordinate to the directive principles, was not agreeable by the structure of the Constitution. Defending the impugned sections, the Attorney General argued that when a law was enacted to further social and economic justice as advocated under the directive principles, it could never cause any injustice or violate any fundamental right for that matter. Moreover, Section 4 did not snatch away judicial review totally, rather questions like reasonable and actual nexus of the law with the essence of directive principles supposed to be furthered, etc., would still be exposed to judicial scrutiny and hence is not unconstitutional. Accepting the challenges made, the court declared both Section 4 and 55 as unconstitutional. The court observed that by virtue of Section 55, Parliament was doing something in garb of an authority which was not permissible by the mandate of the Constitution. Also, Section 4 attempted to legitimize all future laws hitting onto fundamental rights, yet judiciary would be paralyzed to the extent of only drawing out and stretching the law to meet the nexus with principles of directive principles. Owing to this decision, while the text of Constitution of India bears the words principles of Part 4 in Article 31C, the same has been declared invalid by this case. The case therefore shows the extent the judiciary would go in order to preserve the inherent character, basic feature of the Constitution. Further, in the case of Tinsukia Electric Supply Corporation versus State of Assam, AIR 1990 SC 123, the court read the doctrine of reasonable nexus to enunciate that it was not that every statute which has been enacted with the dominant object of giving effect to the directive principles is entitled to protection, but only those statutes which are basically and essentially necessary for giving effect to directive principles are protected.